Hello? Yes. Okay, everybody, thank you. This is just a quick reminder that there are 2 parallel sessions in the other room, so please check the agendas just to see if something there will interest you. And without wasting more time, because I am the party pooper, somebody called me out there, the timekeeper, I will give the floor straight to you. Thank you very much.
So, good morning, and thank you to everybody who's attending our panel. This is a joint effort made by a number of institutions and groups operating at academic and international level. So, the co-organizers are the Interest Group on International Health Law of the European Society of International Law, which Ashwini, Kumar, and I coordinate. The Legal Preparedness Action Package of the Global Health Security Agenda, and then we will speak about Kathy Ginsberg in a moment, and 2 EU-funded projects, Jean Monnet actions, namely 2 modules, one on One Health Global and EU Perspective, the other one promoting operationalization of One Health through EU juridical tools. And these are 2 projects funded by the European Commission, specifically focused on One Health implementation and its legal perspective. So as you can see from the title of the panel, we wish to focus on the role of law in One Health implementation and governance. This field appears to us to be sometimes underdeveloped and underexplored, though it's a very important perspective if we think about ways that can support One Health governance and cooperation at various levels. So our aim is to stress the importance of legal preparedness. Legal preparedness as a fundamental precondition, a necessary requirement for an effective and successful operationalization of the One Health approach at international, European, and national level. So, if One Health aims at designing and implementing programs, policies, and research in which multiple sectors communicate and work together to better prevent and respond to complex health threats arising at the human, animal, and environmental interface, what can law do? How can law support all the process? Law at all levels forms the backbone of appropriate frameworks for coordinated implementation of the One Health approach, and several initiatives at international level are developed and are progressing to promote technical guidance and to support interinstitutional collaboration and intersectoral governance mechanisms at all levels. So, in this perspective, the panel will examine and discuss such key initiatives promoting legal preparedness for One Health, including within the framework of the negotiating process of the WHO Pandemic Treaty, under the umbrella of the work of the GHSA Legal Preparedness Action Package, and with relation to the tools elaborated by the Quadripartite Coalition, WHO, WHOAH, and FAO and UNEP, and the contribution also of the European Union cross-agency One Health Task Force. We will also delve into the analysis of meaningful national case studies like Italy. I'm not playing for my country, but nonetheless, it seems to offer some good practice with the establishment of a One Health dedicated department within the Ministry of Health to facilitate intersectoral and interinstitutional collaboration for best outcomes. So turning now to our panel. My name is Stefania Negri. I'm based at the University of Salerno. I'm the coordinator of a couple of Jean Monnet actions, as I said, funded by the European Union. One is a center of excellence dedicated to the role of the European Union in global health, and its name is New Visions of the European Union's Role in Global Health, and this module, which is focused on both global and EU perspectives from One Health. And I'm also a member of the national Italian delegation to the Global Health Security Agenda, Legal Preparedness Action Package. And within this framework, recently with Kat Ginsberg, we have started the work. We have launched a new sub-working group on One Health, and we are trying to networking and streamlining all international and regional initiatives to join forces and make this approach progress, especially from a legal perspective. We have as panelists, and I thank them very much for accepting our invitation and for being in with us, Dr. Mark Eccleston-Turner. He's Senior Lecturer in Global Health Law at King's College London. He's a member of the Global Health Law Consortium and has been and is still an expert advisor on PAPs for several working groups, including delegations and working groups acting within the realm and within the framework of the negotiations of the pandemic treaty. And Mark will address exactly the role of One Health within the new WHO pandemic treaty draft, and he will try to track the development. He will offer a perspective on the development and changes of how One Health is formulated in the pandemic treaty, analyzing why it has proved to be so contentious in these negotiations, and arguing where the sector goes from here. Then we have Mrs. Catherine Ginsberg, Senior Associate of the O'Neill Institute for National and Global Health Law at Georgetown University of Washington. She is the Secretary and member of the leadership of the GHSA Legal Preparedness Action Package, as I said, and I have the honor of co-chairing this newly established sub-working group with her. And of course, she will talk about the work and the perspective of the work done by this new sub-working group. The title of her presentation is Integrating One Health into Global Health Security, Strengthening Legal Preparedness. She will explain how legal framework can be enhanced to better support the integration of One Health principles in global health security efforts. She will highlight the role of international collaborations and legal preparedness play in preventing and responding to zoonotic diseases under the global health security agenda. Then we have the pleasure of having Mrs. Carmen Bouillon, legal officer at the Development Law Service of the UN Food and Agriculture Organization. She's deeply involved in One Health work, and she has actively promoted and contributed to the framing and designing and launching of specific assessment tools and other legal tools for the benefit of national governments. The title of our presentation is, in fact, One Health Governance from Global Collaboration to National Action. And she will identify key challenges in governing One Health at both global and national levels, suggesting valuable lessons that can be applied to the broader One Health approach, building on the experience, especially of antimicrobial resistance legal frameworks. And then we close with my dear friend and colleague from Italy, Professor Dr. Flaminia Aperio-Bella. She's Associate Professor of Administrative Law at Roma III University and module leader of the Jean Monnet module protecting operationalization of One Health through EU juridical tools. She will explain and she will address all the work that she's doing within this project, and her presentation is titled Promoting the Operationalization of One Health through Organizational Measures, EU and Domestic Experiences. So we go from the global to the regional and national, top down. We try to offer you as much as a complete overview of what is being doing, what is done and is under progress at all levels to promote and to advance the legal perspective and legal preparedness in this respect. And so she will focus on the work of the EU One Health cross-agency task force and also on some national case study, especially Italy, which is most familiar to us, but she doesn't have time to maybe this can be an object of discussion later, to explore other national case studies, but then we will see. So without further ado, I think I can stop here and leave the floor to Dr. Mark Eccleston-Turner. And thank you again, Mark, for being with us.
So thank you so much, Stefania, for that kind introduction. So, as Stefania said in her introduction, I'm a global health law scholar rather than a One Health scholar. But, I mean, you might argue that you can't do global health without doing One Health. But because of the prominence which One Health has had in the pandemic treaty negotiations, I have inevitably had to become interested in One Health. So for those of you who are not familiar with the pandemic treaty, and I imagine there are quite a few people who are not, the pandemic treaty was initially proposed back in early 2021, largely as a tool to try and make up for the deficits which we saw in global health governance and global health law brought about by the pandemic treaty. And they were brought about by the COVID-19 pandemic. So the pandemic treaty was very much meant to be a response to what went wrong in COVID-19, particularly around issues like sharing of information, sharing of vaccines and antivirals, a lack of coordination within the global system, countries imposing trade and travel restrictions on each other. And One Health came to the fore as well, largely driven by the fear of spillover events and the theory that COVID-19 originated through a spillover event in a wet market in Wuhan. So that underlying logic is that global health governance really failed during COVID-19, and we needed to do a number of things to improve it. One of the interesting things about being here in Brussels is that one of the initial proposers of the pandemic treaty was the European Union itself, who put in place a lot of political support for the idea of it and proposed a lot of the text. So, way back in 2021, the World Health Organization and a coalition of willing member states put forward a list of wishes, a wish list for what the pandemic treaty was intended to achieve, and including a lot of sort of quite vague language around all of government and all of society approaches, greatly enhancing international cooperation, not just enhancing it, greatly enhancing it, because these superlatives matter. Part of this initial proposal was that there should be a recognition of a One Health approach that connects the health of humans, animals, and our planet embedded within this treaty. Now, this is a major distinction from the current set of legal rules which were in play at the time, the 2005 International Health Regulations, which are very much focused on the health of humans rather than the health of animals and the environment at large. So right from the very early days, there was this recognition that One Health needed to be embedded in the treaty. And member states began the process of what I will refer to throughout this talk of meeting in INB. The INB is the intergovernmental negotiating body of the World Health Organization. This is the negotiating forum through which member states met to negotiate the treaty. And interestingly, despite the fact that One Health is meant to be at the center of this approach, One Health wasn't mentioned until the 5th round of negotiations, which is quite odd, okay? And it took even longer for clear definitions of what One Health actually means to appear in the negotiations. One of the things that became a particular challenge right from the start is how One Health actually fits into WHO's constitutional remit. So from the very early days, the idea was that a treaty would be negotiated under Article 19 of the World Health Organization's constitution, which is the article which allows it to draft treaty law within the competence of the organization. The competence of the organization, or the objective of the World Health Organization, is the attainment by all peoples of the highest possible levels of health. And there were discussions right from the early days about, well, to what extent does One Health fit into this? Particularly the aspects of One Health that are not related to human health. the bits of One Health that are related purely to animal health without risk of spillover events, or planetary health without risk of causing detrimental effects to human health. And at the early stages of the negotiations, there were discussions around whether this treaty should even be housed in the World Health Organization at all, because of that very limited constitutional remit which it has. WHO can only make law to the extent that it can only address things within its remit to the extent that they impact upon human health. So there were proposals in the early days that we should push this treaty out of the World Health Organization, house it somewhere like the General Assembly in New York, which has a much broader remit, isn't just confined to talking about human health, but can take much wider approaches. And there's question marks about to what extent you can deal with particularly upstream prevention in One Health when you're purely focused on making law related to human health. Despite this very clear barrier, the member states decided to house the treaty at the World Health Organization, pushed very much by WHO itself, who were very keen to have the treaty housed under its remit to ensure that it remained the preeminent organization in the international sphere that's related to human health. There was concerns that if there was a treaty on pandemics that was housed at the General Assembly, it might weaken the normative authority of WHO. So they decided to keep it in Geneva. Now, it might seem fairly unusual to those of you in the room who work on One Health, but One Health has been a really controversial topic. And you might think, well, why? It's fairly uncontroversial in many ways, right? We should care about human health, we should care about animal health and planetary health and their interactions. But right from the very early days, the idea of One Health being in this treaty was highly controversial. Including an open letter which was signed by 60 civil society organizations and non-governmental organizations, including Oxfam, the People's Health Movement, Third World Network, warned that One Health provisions in the pandemic treaty were intended to boost pathogen surveillance in low and middle income countries and could enable developed countries to erect more trade barriers and data demands on developing countries, impose more costly measures on low and middle income countries that poor countries cannot afford to implement. So quite early on, One Health was seen as a tool of in the negotiations. One Health was seen as this tool of high-income countries to place even more surveillance obligations on low and middle-income countries, impose even more Western standards of animal husbandry and animal and food safety practices on low and middle-income countries, and that this was One Health was being used as a tool to impose these kind of post-colonial logics on low and middle-income countries. So that was the initial framing right from the very start, which might surprise lots of people in the room who are interested in One Health. What also happened in the negotiation, oh, hang on, I'm on the wrong, there you go. What also happened in the negotiations was that One Health very quickly became placed in conflict with the idea of pathogen access and benefit sharing, or PABs, which is another aspect of the pandemic treaty, which is designed to ensure access to medicines in low and middle income countries when samples are used from low income countries to develop medicines. So it was these two ideas were very much placed in conflict with each other right from the very, very start. One Health being seen as a tool of the global north to ensure that they could have better surveillance, better data, more trade barriers in place on low and middle income countries, and PABs became weaponized by low and middle income countries to try and push back against some of these standards around data sharing and surveillance, and say, well, if you want all of this data, if you want all of this surveillance, what do we get back in return? Where's the medicines which we so desperately need? This was confounded by the fact that issues covered within One Health also fall under the jurisdiction of multiple other international organizations, and we have a speaker here from FAO, and One Health clearly fits within FAO's remit, as well as UNEP and the World Organization for Animal Health. I'm still not sure what the acronym, how we say it, WOAH? Is that how, WOAH? How we pronounce that. So there were issues around constitutional remit of international organizations as well. And the Quadripartite aside, which is one of those quite rare instances of international organizations choosing to work together in a really effective way, cross-regime interaction between international organizations within the UN system is actually quite rare and actually quite difficult to facilitate. So it's not as easy as going, well, we'll just all work together on One Health. International organizations can be quite territorial about their remit and how they share resources and how they choose to work together. So there were concerns that the pandemic agreement could undermine already existing frameworks in other international forums that work on One Health. So, as I said, member states were very reluctant right from the start to actually put in place very clear language related to One Health. Very early on in the negotiations, and this is from INB 2, so the code at the top of INB / and then the number tells you which round of INB we're talking about. In the very early days, language related to One Health was confined just to the preamble. And for those of you who are not international lawyers in the room, the preamble is like the introduction before the main agreement. This is not legally binding language if it's contained within a preamble, and it is just used to interpret the rest of the agreement. So it doesn't form any clear legal obligations if it's preambular. And right from in those very early rounds of negotiations, member states confined One Health just to preambular information and talking about the importance of a One Health approach, but not defining what a One Health approach actually means and not placing any concrete obligations around it. So we can see there just recognizing the importance of these issues in those early rounds of negotiations. We got our first definition of One Health in the 5th round of negotiations, which was in the summer of last year. And you can see those on here, which are, you know, very broad definitions around a integrated, unified approach, which is meant to balance and optimize the health of people, animals, and the ecosystem, and that the health of humans, plants, animals, and the wider ecosystem are interlinked. And that is basically all we got at this stage. And also, very little substantive obligations from this. So at this point, which is last summer, we're just told One Health matters, and this is what One Health actually is. If you think back to those very early days, that this treaty was meant to be grounded in One Health and address those One Health issues which can cause to or exacerbate the pandemic, quite weak language for quite a while. And we ended with this being the definition which was included in the pandemic, the final agreement which we have at the moment, which is this sort of fairly broad definition around One Health. So it took a while to get to this point of even explaining what One Health actually is. So from that, what did we actually get? What are the substantive obligations around One Health in the pandemic treaty? So this is the final text that has been agreed by member states, and it will go to the Health Assembly in a few weeks. The language that's included around One Health is really interesting, and in particular, I would argue, is incredibly weak and creates very few binding obligations for member states. And I've tried to highlight some of this really weak language in bold here. So the parties commit to promote a One Health approach for pandemic preparedness and response. Commit to promote. I'm not really clear what commit to promote actually means. That is a fairly weak, unsubstantiated obligation. How do you demonstrate that you've done that? How do you demonstrate that you've fulfilled this legal obligation in this treaty as a member state? How do you show that you've committed to promote something? And it also, lots of the language around One Health has this final phrase, which you can see in Clause 1, which is taking into account national circumstances. This is a phrase which appears quite a lot through the pandemic treaty, which is highly deferential to member states. It is saying, this is what we would like you to do, but you have free will to do that, taking into account your national circumstances. So let's say you're a very large palm oil producing nation, and your economy is quite vibrant and relies quite heavily on this. You might say, well, I recognize that I have a One Health, I have to promote One Health, but I do have national circumstances which requires me to chop down huge amounts of the rainforest and plant palm oil plantations, because this is such a huge amount of, such a huge economic boost for our society. This is the kind of language which we see in the Paris Agreement around climate change, which is highly deferential to this idea that countries have it within their national circumstances to decide how far with these obligations they want to go. And secondly, you see, again, language around commit to identify and address the drivers of pandemics and introduce relevant pandemic preparedness and response plans. All that's really telling member states that they have to do is recognize One Health within their pandemic preparedness and response plans. I would argue that member states are already doing that by and large, and you don't need a legal obligation in a treaty to make countries actually do that. And again, we see more language around in accordance with our national context, have relevant national policies and strategies, promote or establish One Health training. And then the final aspect which I wanted to highlight is this idea that the modalities and terms and conditions of a One Health approach will be further defined. So what's going to happen next is member states have paused negotiations on the pandemic treaty, and they're going to negotiate 2 annexes to the agreement, one of them on PABs and one of them on One Health. And if you remember, those were the 2 ideas which have been in conflict with one another right from the very start. So there is a hope or a possibility that stronger obligations will be created through these annexes, and the annex on One Health and the annex on One PABs. But given the content which we actually have here, and given how negotiations have gone so far, I think that is fairly unlikely to happen. So in terms of the international context which we currently have within One Health through the pandemic treaty, I would argue that it actually imposes very few, if any, meaningful obligations on member states. And actually what the result of these negotiations to date is a reassertment of the status quo. So if we are going to look for meaningful legal obligations around One Health, perhaps it would be better if we looked to the regional perspective or the national or subnational perspective, because the obligations which exist at the international level are clearly not sufficient to try and address these drivers of climate change, these drivers of pandemics, and take a meaningful One Health approach. But perhaps we shouldn't be looking to the World Health Organization to do that. Perhaps we need to look to other forums within the international organizations to try and get meaningful commitments and meaningful agreements around One Health. And I shall leave it there. Thank you.
Thank you so much, Mark, for offering such a broad and detailed perspective on the current status of the negotiation of the pandemic treaty, and thank you also for sticking to your time slot. I highly appreciate it. So, just to start the discussion, which we will develop later, I have huge curiosities, but cannot ask everything now. But I would like for subsequent discussion maybe that you give us some more information on the inconsistencies between the choice. Is it an approach? Is it a principle? I know that Carmen is doing some legal research on this, but I would like also to know your thoughts about this. And also, you sound very pessimistic about the real added value of this part on One Health in the treaty, and also the prospective annex. So do you think that apart from the contents, weak as it may be, they will succeed in overcoming all the problems that they've had since 3 years ago, and do it all in one additional year, and how this will impact on the entry into force of the treaty? And also, I think that this brings about huge problems with liability and compliance, as you said, because there's no measure to assess the compliance of these very weak / almost inexistent legal obligations. So we will open the floor for questions and answers afterwards, and I give the floor to Kat Ginsberg for a presentation. Thank you both.
Thanks, Stefania. Just move these. sorry, I'm just looking. Pretend that there's like colorful things on this because it doesn't seem like it transferred, but so today I'll be speaking on the Global Health Security Agenda, as Stefania mentioned, providing an overview of GHSA, Legal Preparedness Action Package, and the One Health Subworking Group. So just for context, the Global Health Security Agenda was stood up in 2014, and it serves as a multilateral, multi-sectorial effort designed to accelerate progress towards full implementation on the international health regulations. GHSA brings together more than 70 countries, international organizations, non-governmental organizations, and the private sector working to achieve the vision of a world safe and secure from global health threats posed by infectious diseases. And at the November 2022 GHSA Ministerial in Korea, GHSA members launched the third five-year phase known as GHSA 2028, for which partners will continue to work towards an overarching target of a safe and secure world from infectious diseases. Okay, so the vision around GHSA is an increase in health security, and it works to do this through enhancing country capacities to prevent, detect, and respond to infectious diseases, emphasize global health security, promote collaboration, and focus on common measurable targets. And the governance structure itself is, it has a GHSA steering group that oversees the Secretariat, permanent advisors, time-limited task force, action package coordination task force, and action package working groups. And the action package working group is the, within that, there's zoonotic one that's focused, one on immunization, and one on legal preparedness, which I'll talk a little bit more about later. So during COVID, we saw investments that GHSA previously leveraged in the global response. For example, a previous GHSA-supported outcome for immunizations was focused on the national vaccine coverage and access and delivery improvable targets. During COVID, we saw that pivot, and it became surveillance for adverse effects from immunization, which was established, microplanning for COVID-19 vaccines conducted, and logistics, cold chains expanded for COVID-19 vaccines as well. And another example is real-time surveillance and reporting. So previous GHSA-supported outcome was focused on infectious disease surveillance improvements, integrated electronic reporting improvements. However, during COVID-19, those surveillance systems shifted and were used for reporting on COVID-19 confirmed cases, deaths, hospitalizations, reporting information used to deploy a rapid response team and initiate contact tracing. So GHSA has kind of been in the sphere of responding to real-time health threats. However, during COVID-19, we saw that legal preparedness was severely lacking around the world. Many countries cited this capacity as one of the major challenges during the WHO-IHR monitoring and evaluation framework consultations in March of 2021. And during widespread health emergencies, a lack of legal preparedness has resulted in major barriers to a rapid response, as seen during COVID-19, including accessing vaccines, lack of sufficient coordination of response agencies for emergencies, and regulatory obstacles to accessing PPE. There is a need for addressing legal challenges to the extent possible between emergencies and not during them, especially given that every minute during a health emergency can mean lives lost. So what is legal preparedness? So in the context of public health emergencies, legal preparedness is the capability to map, develop, refine, and use legal instruments that enable the implementation of capacities across sectors to prevent, prepare for, respond to, and recover from health emergencies. This involves identification of legal approaches that can promote an effective response to public health emergency and the strategic development, refinement, and the use of legal instruments, constitutions, legislation, decrees, regulations, to facilitate the implementation of capacities needed for strong health systems. Legal preparedness for public health emergencies aims to facilitate efficient and effective coordination among relevant multi-sectorial stakeholders and to support the overall continuous process of preparing for and responding to public health emergencies. So legal preparedness is cross-cutting and critical to achieving health security by promoting a coordinated approach to building a legal infrastructure. It ensures that legal authorities and capacities are already in place to be operationalized and that legal issues are resolved in advance whenever possible. Legal preparedness saves time in responding to health emergencies, and therefore more time and energy are reserved for public health, communication, and scientific dimensions of the response. It requires advanced planning and implementation through a wide range of interventions. Legal authorities and capacities will ideally not be established during a public health emergency. And legal preparedness is a critical component of global health security. Having a strong integrated system of legal preparedness in place ahead of crisis can facilitate the prevention, detection, and rapid response to public health emergencies. And legal instruments can help create sustainable legal infrastructure that can support consistent decision-making at all levels before and during an emergency response. So basically the main takeaway is we want to really work on creating these legal frameworks and mechanisms during more peacetime events. So as a result of this critical gap, the GHSA Legal Preparedness Action Package was launched in September of 2021, and it aims to strategically build a strong foundation and technical tools for legal preparedness to guide and support country-level capacity building and promote the role of law in overall health security, and GHSA capacities for an effective public health emergency response. So it aims to bring countries and key experts together to build a solid foundation and common understanding of the competencies necessary for strengthening public health legal preparedness by developing technical tools to guide and support countries in strengthening their legal preparedness capacity and advocating for greater awareness globally about the role that legal preparedness plays in preparing for health emergencies. So our mission is to promote legal preparedness as a critical capacity for an effective public health emergency response and for strengthening global health security, with the vision being that legal preparedness is globally recognized and understood as a critical capacity for effectively responding to public health emergencies and for global health security. Currently, we have over 40 members of the working group, which is composed of governments, CSO, academic, nonprofit, and some private sector entities. And as part of the working group, last fall we launched the One Health sub-working group, which is dedicated to fostering collaborative, interdisciplinary approaches that address the interconnected health challenges at the human-animal ecosystem interface. And our objectives are to strengthen governance mechanisms, enhance public health systems, promote environmental sustainability, ensure a comprehensive response to emerging zoonotic diseases, support states to integrate One Health into legislation and policy across sectors. And establishing a One Health framework in law and policy is necessary to address the multitude of interlinked global health and sustainability challenges, including the risk of emerging and re-emerging infectious diseases, climate change, antimicrobial resistance, and food insecurity. Currently at the international level, a broad collaboration has been underway to address this for several years. The Quadripartite cooperation, which Carmen will speak to, is one of the most significant high-level initiatives to strengthen the adoption of One Health approach to human, animal, and environmental health. At the national level, legal frameworks include a variety of sectorial legislation that is relevant for the One Health approach, which include public health, food safety, sustainable wildlife management, environmental legislation, biodiversity, and animal health. And to implement One Health, major structural changes are required to integrate the human, animal, and environmental health fields and to support multi-sectorial communication, collaboration, coordination, and capacity strengthening. Critical gaps in One Health implementation include databases and resources to support information sharing and action in line with a One Health approach, identification and showcasing of best practices for One Health implementation, mapping of existing initiatives and capacities for One Health research, and building the next generation of One Health workforce, a model for an integrated One Health surveillance system, mechanisms for routine and emergency coordination with relevant stakeholders, a more complex understanding of the drivers of spillover zoonotic diseases, a standardization approach for assessing risk of spillover pathogens between different animal populations and humans, and emergence of zoonotic diseases, including those arising in food systems, and methods for identifying and reducing spillover risks and spread of zoonotic diseases in ways that minimize trade-offs and maximize co-benefits with other health and sustainable developments. So you can see there's a lot of work to be done. And there are immense benefits of implementing One Health to address issues, and One Health legal preparedness plays a critical role in enabling countries to effectively implement the One Health approach by developing comprehensive legal frameworks, policies and governance mechanisms that bring together various sectors under a unified approach to manage health risks. These frameworks ensure that stakeholders from various sectors, including public health, veterinarian, environmental, and agricultural, can work efficiently and in unison when addressing emergent diseases or preventing zoonotic outbreaks. So the One Health Subworking Group is looking forward to supporting and establishing new legal support mechanisms at the international, regional, and national level. If you're interested in learning more or joining the GHSA Legal Preparedness Action Package or the One Health Subworking Group, please feel free to either contact Stefania or myself or reach out to the email that is provided. But that's just kind of like a brief overview of GHSA and where we're headed. So thank you.
Thank you so much, Kat, for just launching the idea that we can network with other institutions, which is what we aim to do, of course. And I think we could also push forward a more focused reflection on a legal definition of our health, which is, lacking at the moment. And so what we want to do with this subworking group is really help governments to develop an integrated interdisciplinary legislation to avoid overlapping inconsistencies between sectorial legislation and regulatory frameworks. So I think this is what we are going to do in the coming months. And please, Carmen, the floor is yours.
Thank you very much, Stefania. Let me see how this works. Oh, the big. Yeah, perfect. So, hello everybody. My name is Carmen Bullón. I'm very pleased to be here with you. I'm a legal officer in the Development Law Service of the FAO Legal Office. This means that I work with very many technical divisions across FAO, providing legal support. I'm going to be talking a little bit about the global governance of One Health within the work of FAO, but also through the work of the Quadripartite, to which the FAO is a member. So first of all, allow me to start by saying that One Health is not a new concept. The concept of the interrelation between the health of humans, animals, and the environment is very old and dates back to ancient Greece, and has been repeated by scholars and from different disciplines, including human health, but also animal health, in the past centuries. You can see there, for instance, a reference to Rudolf Virchow, who was a medical doctor, but Calvin Schwab was a veterinarian, and Rachel Carson, focusing on pesticides, just showing this interaction across the health of humans, animals, plants, and more broadly, the ecosystems and the environment. But it was in 2004 that the World Conservation Society formulated the Manhattan Principles, One World, One Health, and the term One Health started being using more profusely. And interestingly, it has been very much the work of international intergovernmental organizations, including the FAO, UNEP, WHO, and WOAH, that has pushed the agenda for One Health. And in fact, this has been incorporated in the agenda of these different organizations for many years now. The first tripartite concept note that addressed One Health dates back of 2010. There was first a memorandum of understanding to collaborate specifically on One Health and antimicrobial resistance, signed by the FAO, WHO, and WOAH, at the time OIE, in 2018. And this was expanded in 2022 to incorporate UNEP. Right after the Berlin conference expanded the scope of One Health to highlight and emphasize the importance of the environment in One Health. So since then, there is a very genuine interest in working together and a very active collaboration. And this collaboration is materialized through a quadripartite secretariat that's composed of the 4 organizations with the chair is rotational, and that has key strategic priorities in providing policy advice, strategic development and capacity building, and to develop evidence and knowledge. And the quadripartite has set up an expert meeting. It's named the One Health High-Level Expert Panel, OLEP, that is already in its 2nd term and develops knowledge products and has done things so important as developing a definition, which is certainly not the only definition, but is a definition that has achieved great consensus and is the definition on which the definition in the pandemics agreement is based. It's not copied verbatim because they have removed the very last part of it, but the rest is copied from the OLEP definition. And this is a great achievement because before this definition, there were around 20-something definitions, each of them focusing on a different aspect of what is One Health. So this definition is a non-anthropocentric definition. It's very broad. It's an expansive definition. It brings a lot of different elements and the possibility for One Health to serve as a guiding concept and principle to illustrate how this approach can be applied to different global health and environmental challenges. So the quadripartite has developed 2 landmark documents. One of them is the One Health Joint Plan of Action, which sets up a number of action tracks I'll refer to immediately. But then there is also, and this is very interesting for the meeting today, a guide on how to implement this joint plan of action at the national level, meaning how to translate effectively One Health into action at the national and regional level. The joint plan of action has 6 action tracks. It's very little. I hope you can see it there. But they go from the identification of risks to also the integration of the environments. It's very varied. It shows really the breadth of this concept and the different dimensions it can cover. And very interesting for this panel, governance and legislation are identified as the first pathway to promote change at the national level. So it's recognized that legislation has a critical role in implementing policies and the One Health approach at the national level. Another quadripartite initiative that I want to highlight is the One Health Knowledge Nexus. This is interactive space for the exchange of knowledge. It's composed of several communities of practice. Right now, there are some that are already very active, one on return on investment, making the economic case for One Health, why it's economically profitable to work under One Health approach, collecting evidence and writing papers and other contributions on this topic. There is one very specific on acaricide resistance, then there is another one on biosecurity, another one on reducing the need for antimicrobials. There are 2 new ones that are about to be launched on laboratory diagnosis and another one on information and communication technologies, very closely connected to data management. And very importantly, we're about to launch a specific community of practice on One Health governance. So please, those of you who are interested, sign up and participate in the launching next Wednesday. This is aimed to be a very, very open and member-driven community of practice to serve for exchanging practices, but also ideas on how to better strengthen One Health governance. So on the basis of this work, some of the challenges I wanted to share with you, but primarily from a regulatory perspective, is that indeed the different areas that are relevant to One Health have traditionally been regulated and implemented at the national but also the global level in silos. So breaking these silos will take time, and it's not easy because we are all humans and silos are always protected. Also, from a regulatory perspective, these different health and ecological challenges that can be addressed through a One Health lens may require slightly different approaches and governance structures. So it's not that we can talk about one gold standard governance structure for One Health that can be applied equally to zoonosis management, AMR, or climate change. We need to think about it, how to tailor it, how to make it more efficient. Some of the areas within the realm of One Health respond to different legal principles. Some of them are based on scientific evidence, others on the precautionary approach. The border between these two is not easy, so addressing One Health from a legal perspective needs some thought about this. There are a lot of reluctancy around data sharing. Participation is uneven. It's not always achieved consistently. And also, very importantly, the legal nature of One Health, what we're talking about, remains very underdefined. And this creates trouble to consistently incorporate One Health in legal instruments. So now, I'm going to give you just a snapshot of some of the work that we have done on AMR, on antimicrobial resistance, which is meant to be the quintessence One Health thing. I start always with this diagram because it shows very well how lawyers we approach these issues. Technical people tend to see AMR, but also other One Health challenges as one single problem, interconnected. But for us lawyers, this is a combination of a lot of different laws that we need to make work together like a big puzzle that is, includes the right connections in the right places. I mean, indeed, AMR is a global health challenge, cannot be covered by one sector individually, demands institutional coordination and collaboration, includes a sustainability dimension, the sustainable use of antimicrobials, and requires stakeholders' engagement. So it's really a core One Health issue. But understanding it from a legal perspective is not easy. So first in FAO in 2015, we started working on a methodology to understand what is AMR from a legal perspective. And we were able to identify core legal areas that were important for AMR. So we developed this methodology, which is online, that's divided into chapters. There is a chapter on governance, there is a chapter on human health, a chapter on human health from a food safety perspective, which is within the realm of the FAO. Then there is a chapter on animal health, environment, etc. But we realized that this didn't have a real, truly One Health approach. So we partner with Quadripartite colleagues in the development of a Quadripartite One Health legislative assessment tool for antimicrobial resistance that has been launched already and is about to be put online. So this is an exercise that we have done across the 4 organizations for trying to understand how to better address AMR from a regulatory perspective. And in addition to this, we have also developed AMR Lex, which is a data set of legislation relevant to AMR. Some of our key conclusions out of this exercise is first that in the case of AMR, which is easier to define because it touches upon a limited number of areas, a legal architecture to address AMR requires a combination of cross-sectoral and sector-specific legislation. But that it is very important that there is some cross-sectoral legislation where we can accommodate responsibilities for collaboration across different institutions. This could address, for instance, the establishment of an AMR governance mechanism, so declare AMR of common interest, provide a legal basis for integrated surveillance. So there is some things that could be achieved through an instrument of this kind. But this cross-sectoral legislation should never, ever introduce sector-specific elements, as that would lead to legal fragmentation. Imagine an AMR law that touches upon a little bit of the regulatory framework of veterinary medicines. So that would lead to having 2 different legal instruments on veterinary medicines. One that's the AMR one, and another one for everything that's not really AMR. That would create legal fragmentation in the legal framework for veterinary medicine. So a balance between what's put at the cross-cutting level and what's left for sectoral legislation is very important. Other lessons that we have learned is that, first of all, that One Health is an approach. So it's applicable to a diversity of different health and ecological challenges. And each of these challenges may require a slightly tailored response. So it's not that we can come up with a methodology to apply One Health across different areas of law that applies equally to all these areas. And I think it's very important also that we recognize that One Health is much more than zoonosis management or pandemics or AMR. It needs to be something much more cross-cutting. But that still, this issue of needing a combination of cross-sectoral and sector-specific legal instruments applies, because it's important to maintain sector-specific legislation with its own consistency. And as opposed to AMR, which is quite focused on anthropocentric interests, One Health is not anthropocentric, so we really need to try to think about it from an equity across sectors and disciplines perspective. So we are working on this, in this sense, to identify concrete legal elements that are actionable and that could apply across all areas relevant to One Health. And we have identified, and this is what we are applying, institutional coordination to be kind of the core one, because it's very natural and comes with the whole idea of One Health. But also to avoid legal silos, so that to make the necessary connections across different laws. The sustainability element, which should be also embedded in One Health and is an integral part of the definition, beyond human interest, thinking about the health and welfare of all species beyond its mere utility to humans, but for respect to these species and in their own kind. And also the importance of participation, inclusiveness, as a core element of One Health. It's very important to respect all forms of knowledge and to integrate all groups and a human rights-based approach so that One Health can be effectively implemented. And this is all from my side. I hope I stayed with the time.
Yes, indeed, you stayed within your times, and thank you. And thank you so much, Carmen, for highlighting the great work that the Quadripartite is doing. And maybe one curiosity that we could a little bit develop in our discussion is, how do you materially transfer these tools and the knowledge to good practices to governments? So the idea of this community of practice is fantastic. We will all join, I assume. And how do you facilitate access? So, for example, can a government apply directly to FAO or the Quadripartite to receive legal or technical assistance to draw legislation to progress on the legal side? And this maybe will be our next step. And so, without further ado, I leave the floor to Flaminia Periobella.
So, thank you very much. I'll try to skip. Okay, here, probably. The big one, the green one. Okay. I have to wait, probably. Okay. It's not mine. It's not my presentation. Okay. I hope that. Try to do. Wait. Okay. Sorry for that. I wait for a signal to start, probably, or I try to skip. Okay. Okay, wait. Probably I prefer to wait. What? I have to go on without it. It's a pity because it's useful, but no, it's not mine neither. We can make it. Probably. Better to start? They don't have it. Okay, so I'm sorry for that. I hope that they have a chance to share it somehow. Good morning, everybody. I'm Flaminia Pariobella. I'm a professor at Roma Tre University, where I teach administrative law, health law, and it's been a while now that I teach also One Health from a legal perspective. I'm very honored and grateful to be here. I thank Professor Stefania Negri for her kind introduction and thank all the organizers for the invitation to this fascinating HELT Symposium. And even if I can't show you my presentation, I would love to start with a conceptual background. So I would like to begin by outlining 3 assumptions grounding my presentation. And not only this, the same 3 assumptions represent the conceptual basis of the teaching and research activities that we are carrying out at the Roma Tre University within our Monnet module, PROHTECT, so devoted to the promotion of the operationalization of One Health through EU juridical tools. First of all, One Health goes beyond infectious diseases. This is something we heard from Carmen. The One Health high-level expert panel definition of One Health approach offers a broader perspective for shaping policies to meet the challenges of a sustainable future for the planet and its inhabitants. It's not a coincidence that the word disease no longer appears in such a definition and having been replaced by the term well-being. Another assumption is that One Health is about methodological innovation. So the innovation of the One Health approach lies in the methodology required for its implementation, which calls for mechanisms for coordination, communication, collaboration, and capacity building. As we heard, One Health is not a new concept. The idea of interconnections between human, animal health, climate, and the environment dates back to Hippocrates. So what's new is the methodological aspect. Agreeing with that, legislation is a powerful means of implementing One Health approach because organizational and procedural tools are key to operationalize the One Health approach because the transdisciplinary intersectoral action required to address health threats with One Health approach must be based on organizational and procedural measures supported by specific legislative and legal institutions. So to introduce One Health approach in legislations means primarily to enable institutional coordination and allow participation. So the next slide is about One Health in EU juridical tools. And so I would like to show that after the COVID-19 pandemic, the term One Health became mainstream in the language of politics, policy, and even law. And there are some interesting data published in a quantitative and qualitative study conducted by Colli and Sebesta in 2023, highlighting several interesting findings. First of all, One Health is mentioned many times in EU documents. Secondly, there is a gradual increase in One Health, the appearance of One Health in legal EU documents, with a clear peak from 2020. And another thing that is, I would like to stress is Even if One Health is mostly mentioned in policy documents and less frequently in documents with binding legal value, in recent times we can register a shift of One Health from a policy tool to an actual, to an actual legislative tool. So the study is based on the data of 2023, but in fact, in the last years, we had other important documents published, and we will discuss them later. So how can define the One Health implementation techniques in the EU? We can say that there are 3 techniques for implementing the One Health approach, and that can be derived from the current legislation. First of all, One Health serves as a guiding principle. This is, for instance, the approach of the EU for Health Regulation of 2021. One Health is presented as a binding legal guiding principle in the pursuit of general and specific objectives related to health. Another technique of implementation is One Health as a tool for policy making. For instance, is the approach of the decision of 2022 mentioning and highlighting the importance of applying the multi-sectoral One Health approach in policy making. But there is also a third technique of implementation that I would like to focus on, which is the implementation of One Health through organizational method. And it is the case of the cross-EU agency task force based on One Health that I will discuss briefly. I would like to say that this One Health task force has been established in 2023, with the aim of collect EU agencies that have a technical and scientific mandate on topics falling under the One Health umbrella. And in 2024, they published a framework for action containing a set of strategic objectives that the 5 agencies intend to pursue together to promote One Health implementation. But what I would like to say is that, as Bronsware and others highlighted in an article 2022, good example of long-standing transdisciplinary cooperation among agencies already existed beforehand. Suffices to mention the fight against AMR. EU agencies used to jointly analyze and summarize AMR monitoring data collected by member states and yearly reported it to the European Union in reports. But after the COVID-19 pandemic, a more stable cooperation was deemed necessary. So we are talking about decentralized scientific agency set up, as we all know, to advise the European institutions and member states in areas of their expertise that affect European citizens. What I would like to stress as an administrative lawyer is that there are many types of agencies, and many types of agencies are involved in the task force. We have regulatory agencies, which plays a major role in implementing the EU's legislation, but also agencies providing technical or scientific opinion, and also agencies aimed primarily to connect competent national authorities to gather, exchange, and compare information and good practices. Overall, the overall goal of the task force is to strengthen the ability of EU and its member states to respond to health crises through a more permanent and established form of transdisciplinary coordination. I would like to stress that the task force is not a decision-making body, but its purpose is mainly to submit recommendations for action and to have an advisory role. So I mentioned there has been a common statement about the mission of the cross-agency One Health Task Force, and this figure shows the 5 strategic objectives of the cross-agency One Health Task Force. And the task force aims to formalize global data gathering and response system for future health threats. And their goals are mainly to strengthen interagency collaboration, including mutual strategic direction and policy support, research coordination, stakeholder engagement, and also, if it's possible, joint procurement and joint activities. So joint activities possibly supported by the joint procurement with the aim of maximizing synergies and avoiding duplication, because this is a point that I would like to stress. About the functioning, we can say that the task force meets at least 6 times a year, bringing together senior officers operating under the auspice of the director of each agency, and a representative of the Commission partake part to those meetings as an observer, and a coordination of the task force is rotates among agencies. We have also another important document recently published about One Health governance in the EU, and it's made by the group of chief scientific advisors. None of them have a legal background, if I well so, and they prepared anyway a scientific opinion on One Health governance in the EU at the request of 2 commissioners, and they were asked to identify forms of management and cross-sectorial collaborations best suited to maximize synergies, consistency, and coherence of intervention, and avoid duplication of efforts in implementing One Health approach. Then they delivered 6 recommendations, and you can see them in the diagram, showing not only the interdependence between the 6 recommendations, but also the pathway to implementation of One Health in EU policies. You can also see arrows somewhat connecting top-down and bottom-up initiatives that should help integrate existing and new efforts in the planning of crucial policies. I would like to focus only on recommendation number 2, which is about coordinated governance. Then here you can find the need to strengthen interinstitutional collaboration, and the One Health Task Force that I mentioned is presented as a best practice to follow, but also other technique of governance that could be and should be enhanced. I would like to emphasize the need to consider the establishment of a multi-stakeholder platform on One Health. So we are talking about an online platform involving all key players from the public and private sectors, providing information, data, links to other relevant organizations, but also educational materials, and in a broader sense, building networks, creating bridges among operational. So what about One Health implementation in Italy? We can say that the path is similar. We have One Health mentioned many times in documents. We have less documents globally mentioning One Health. They are soft law documents and also hard law documents, including primary law documents. And we have also multiple One Health implementation technique also in our country. I would like to focus only on organizational method, and we have 2 examples. One, which is, only a formal implementation of One Health, in my opinion, which is made by the regulation of 2023, which changed the organization of our Ministry of Health, introducing a department devoted to human health, animal health, and ecosystems, One Health, and international relations. I think that it's not exactly a good example, because to change the form of the Ministry of Health is not sufficient, especially when one considers that many crucial areas for the implementation of One Health, such as, for instance, prevention, remain the responsibility of other departments. We heard this morning that One Health is the infrastructure of prevention, so taking prevention out of One Health is a bit not useful. But there is another example that I would like to focus on, which is put forward by the decree of 2022, number 36, with the establishment of the national system for preventing health from environmental and climate risk. I would like briefly to show how it works, because what is meaningful here is the idea to zoom on how the system works, to build, a specific institutional design to implement One Health. So put many actors that operates in the health sector, in the animal health sector, together to work together in a network model. So we have the Ministry of Health, but also the National Institute of Health, working with prevention departments, so structures within regional healthcare facilities, a zooprophylactic institute, and also regions. And then the same model is reproduced at regional level, so still a huge network model at the regional level, which involves also regional facilities delivering health social services and also other entities within the territory. It's not clear who other entities within the territory are, but what I would like to stress is that the task force, there is a task force established within each service, the system for preventing health from environmental and climate risks, the SRPS, to ensure intersectoriality involving those areas whose policies have impact on the environmental health-climate interface. And there is a huge emphasis on the effective integration of information systems at the regional level. And there is also a coordinating structure that let the service I mentioned to talk with another service which is devoted to the protection of the environment. So we have a Cabina di Regia, which has a mixed, which is composed by representatives of the Council of Ministers, the regions, the SNPS, the Ministry of Health, and the Ministry of Environment, to bring together their expertise to work together. So they have a lot of tasks. We are still waiting for the program, Health, Environment, Biodiversity of Climate, the 3-year program that will be delivered soon. But it's still interesting to see how, an institutional design to implement One Health can be useful to implement it really. So to conclude, I would like to say that legal preparedness, as we would like to demonstrate in our panel, is a key tool to implement One Health. And in my vision, organizational and procedural measures are key tools also to operationalize the One Health approach. We heard about converging crises this morning that scares us, but probably through organization we can face them in a more cost-effective way, because I would like to stress also the fact that organization also ensures efficient and equitable allocation of resources, maximizing synergies and avoiding duplication. So we have to bear in mind that organization shapes rights, gives shape to rights, so equity between the 3 pillars must be taken for granted in this kind of institutional organization, and also inclusiveness is very, very important, because as we heard this morning, data does not move politics, but people do, so we have to involve them in One Health policies. So thank you very much. You can...
Thank you very much, Flaminia, also for highlighting the criticalities that can emerge even when you try to make progresses within one national organization framework. And I was also quite critical with the way they have shaped the new departments of the Italian Ministry of Health, but this makes even more evident that there are challenges and there's a strong need to guarantee interinstitutional cooperation even within the same institution. So, but this is work in progress, and we hope that we will find the good solution. So maybe this could open, for example, for a further reflection on what happens in other countries, how we can circulate good practices, and then I come back to Carmen and this community of practice. So can this be a vehicle to inspire other countries to take from the example, to look at other countries, what they're doing and what is best to be done. I would say that we can open the floor to question and answers. We have maybe 15 minutes left. Is there a little bit less? Okay, let's say 10 minutes. We have 10 minutes? Okay, great. So, yes, Professor Quinn. Please allow me to thank you so much, Professor Quinn, the organizers, Ashwini Kumar, for hosting us and for organizing such a splendid and significant event.
Thank you for your panel, which I must say has been with almost military precision. Congratulate you for that. I would just like to start with a pointlessly provocative question. Is One Health an ideology? And if not, why not? Please feel free, anybody who has a point.
Find as an ideology. Sorry. I think One Health can be very many things, but what we, and actually its origin comes from very many things. One of them is the evidence, the scientific evidence of the interlinkage from a, strictly speaking, scientific perspective. So it's really the product of scientific research. At the same time, One Health and other interdisciplinary concepts such as planetary health or eco-health have done a lot of work in integrating different aspects into the actual principle of integration of environmental law. There is need for paying attention to many things for regulating one properly. So indeed, there is a lot of literature on the ethics of One Health that might be beyond that, and it's equally valid within the concept of One Health, which at the end of the day is going to mean whatever you consider it means for you. A different thing is what countries want to bring into their legislation to create concrete obligations and responsibilities. And that may depend on a number of things, starting by national priorities, but also the values of the society, the policy environment, and indeed the international obligations or recommendations. So I think I would leave it there, and I pass the floor to...
I agree with Carmen because it depends to your perspective while describing One Health. I think that it's not no more a concept, it's an approach, it's an idea, it's a way of shaping policies. It's probably not ideologic, but it's linked to probably to values that each has in its viewpoint. So I think that it's all of them, but it's above all an approach, probably a legal principle, if we introduce it in the legal framework. And it could be a useful way to address the health threats, the future health threats with One Health lens.
So I have very little to add from those excellent answers from Carmen and Flaminia. Only to say that it's probably not an ideology because ideologies are better defined and more clear and easier to understand. So it loses its ideology on that basis alone, I would say.
Hi, thank you. My name is Dominika Kuzińska-Błaszkowska. I'm a postdoc at University of Wrocław. And thank you very much for these interesting presentations. I have a very sad conclusion that on international level, we clearly can see that it's not working well. On European level, it's a little bit better. And the best way is to implement it on national level. But then whether this concept can be effective if we implement it only on national level. And the second question is actually because we see that on international and regional level, it doesn't work well yet. Can it work? And to be more productive, maybe, what to do to make it work?
So given the person who sort of started off the high degree of skepticism, I'll deal with that. In terms of whether it's working at the international level or not, so I wouldn't take the conclusion from my presentation that it's not working well. And I think Carmen, given all of the work of the Quadripartite, would say that actually at the international level it's working quite well. What should be the takeaway from my presentation is that we are not doing very well in creating binding international standards around One Health. Now, whether you think binding international standards around One Health are necessary is a matter of debate, a matter of discussion, okay? Quite unusually, I'm an international lawyer who thinks less international law is probably a good thing. I don't think that having treaty with meaningless language attached to it is actually particularly beneficial. But actually, lots of the work that's being done by the Quadripartite, which isn't based in binding international law and is more traditionally what we'd consider soft law, creating guidelines, creating norms, standards, practices, is actually working fairly well. So I wouldn't take the conclusion that the international level is necessarily working badly, but creating binding international law isn't working very well in that. But that's a reflection of member states and what member states want. This is a reflection of the fact that member states don't want to create binding international legal standards that bind themselves in the future. That's a problem for multilateralism. That doesn't necessarily mean that we're not making achievements around One Health at the international level, just that that's not coming through formal international lawmaking. Whether it's working at a soft law level is a sort of a separate discussion, which I'll hand over to Carmen.
Hello, I'm audible? Yeah. Hi, my name is Danish Nathani and I'm a PhD researcher at the University of Antwerp. I had a question relating to the pandemic agreement, and today's presentation is regarding legal preparedness and thinking about key tools to implement One Health. I was thinking in the specific context of tech transfer agreements and technology transfer provisions in the pandemic agreement, where there is a debate regarding voluntary standards for tech transfer and involuntary standards. And the previous answer kind of told us about that probably multilateralism is not the way to go, but to set guidelines and soft governance approaches are better. I was just thinking, I had a question regarding the tech transfer provisions in the pandemic agreement, and how far do you think those are a better tool to implement the vision of One Health? Thank you.
So I'll start on that. Yeah. Despite my previous answer, tech transfer is one of those places where I want to see much, much stronger international legal obligations, as opposed to the work on One Health, which seems to be functioning through the Quadripartite in a fairly successful manner. But you're absolutely right that the standards around tech transfer in the pandemic agreement are incredibly weak, and that is a reflection of the kind of protectionist attitude that lots of high-income nations have taken towards industry in these negotiations, particularly the EU, particularly high-income nations like myself, the US when it was involved, Japan, Switzerland, are very reluctant to have any kind of obligations imposed upon their industry, which is why the tech transfer obligations are so incredibly weak. But that's one of the places where we need much, much stronger binding international law, because it's very clear that the voluntary nature of tech transfer for access to medicines is incredibly underserved. So WHO has a tech transfer project related to influenza vaccines, which I've previously worked on. The technology in that pool, which it's offering to roll out to member states, is largely from the 1960s. It's incredibly out of date. And when we look at the standard material transfer agreements that some pharmaceutical industries have signed with WHO for access to vaccines, industry is fairly willing to donate vaccines. It really doesn't want to give transfer of technology. No manufacturer has agreed to transfer of technology. So we need to be much, much stronger with our obligations around tech transfer. But that requires high-income nations like my own, like the EU, to be much more willing to make their industries work for the common good. That requires a fundamental redress in how we look at industry, and also how we how influential industry have been in framing certain positions that have been taken by high-income countries during these negotiations.
Have to close here because the organizers are saying that we are quite late, but although we started a bit later than expected. So thank you for all of you who attended. Thank you very much to our panelists, and we can follow up on the discussion in whatever moment. So please feel free to contact us and to develop further our reflections. Thank you and enjoy your lunch.